I want you to think about a number for me. Just hold it in your mind for a second. After 40 years of working, of contributing to your 401k every single paycheck, of watching that balance slowly climb from a few $100s to something that finally feels real, what if I told you that one single piece of paper could hand every last dollar of it to the wrong person? Not to your kids, not to your spouse, to someone you might not even speak to anymore. A form you filled out maybe 20 or 30 years ago, tucked into a filing cabinet somewhere at your old HR department, that you have not looked at since the day you signed it. I'm Carol Ann Mitchell. I spent 24 years as a retirement and estate planning attorney in Scottsdale, Arizona, and I retired 8 months ago. 8 months. I'm still figuring out what to do with my mornings, if I'm honest. But what I did bring with me out of that practice is 24 years of watching families, careful families, responsible families, people who did absolutely everything right, get blindsided by a legal mistake so simple that most attorneys don't even think to warn you about it until it's too late. And by too late, I mean your family is sitting in a probate attorney's office, grieving and learning for the first time that the money you spent a lifetime building is going somewhere you never intended. So stay with me on this, please, because the fix, once you understand the problem, takes about an afternoon, but only if you know what you're looking for. I had a client, I'll call her Margaret, not her real name, who came to see me when she was 69 years old. She'd just lost her husband of 41 years. Beautiful couple, 3 kids, 7 grandchildren. Her husband had been meticulous about saving. He had a rollover IRA worth just under $420,000, money from his engineering career, carefully accumulated over 4 decades. She had a will. He had a will. They had done what most people consider the right thing. And then she sat across from me, and I had to explain to her that the IRA was going to his ex-girlfriend, a woman he had dated for 8 months before they even met. Because in 1987, when he opened the IRA at his first real job, that woman's name was on the beneficiary form, and it never got changed. The will said everything went to Margaret. The beneficiary designation said something else entirely. And in a situation like that, the beneficiary designation wins, every single time, without exception. I watched the colour leave her face. I watched 41 years of marriage run up against a form that was older than their relationship. And there was almost nothing I could do. That is the mistake I want to talk to you about today, and I promise you, it is far more common than you think. Here is the thing that most people don't know, and that frankly most HR departments don't bother to explain when they hand you that stack of new hire paperwork on your second day at a job. Your 401k, your IRA, your life insurance policy, any account that has a named beneficiary, those accounts do not go through your will. They do not pass through probate. They go directly, automatically, and legally to whoever is listed on the beneficiary designation form that you filled out when you opened the account. It doesn't matter what your will says. It doesn't matter what your intentions were. It doesn't matter what a judge thinks is equitable or fair. The form is a legally binding document, and it supersedes everything else. Now, most people, when they hear this for the first time, have one of 2 reactions. Either they say, "Oh, I already know that," and then they discover they haven't actually looked at their forms in 15 years. Or they say, "Wait, really?" And they get very quiet. I mean, very quiet. Because that's when the mental math starts happening. When did I open that account? What was my life like then? Who did I write down? I need you to do that math right now, seriously, while we're here together. When is the last time you actually looked at the beneficiary designations on your 401k, on your IRA, on any old employer plan that you rolled over? Not the account balance, the form, the actual piece of paper that says who gets it when you're gone. If you can't answer that question with certainty, I want you to treat the rest of what I'm about to tell you as urgent, because the stakes are real, and the window to fix this only stays open while you're still here to sign documents. I practiced estate law for 24 years, and I saw this particular flavour of disaster in dozens of forms. The divorced man who never updated his 401k and left $500,000 to a first wife he hadn't spoken to in 18 years. The widow who discovered that her late husband's IRA was still in his parents' names from the 1980s, and both parents had already passed away, which meant the account had no living beneficiary and went straight into probate, a process that took 22 months and cost her family over $28,000 in legal fees. The grandmother who lovingly named her 3 grandchildren as equal beneficiaries, not knowing that 2 of them were still minors. When she passed, a court had to appoint a custodian for the minor children's share. There were legal proceedings, and the money was frozen for the better part of a year. None of these people were careless. None of them were irresponsible. They were just human. They got busy. Life moved fast. They meant to get around to it, and they didn't. And I say they, but you know, I also include myself in this. I'll admit something to you. I am an estate planning attorney, and I went back and checked my own beneficiary designations last year when I was making my decision about retiring. And I found one account, an old Roth IRA I'd opened in 2002, where my mother was still listed as the primary beneficiary. My mother passed away in 2016. If I had died before finding that, my husband David would have had a real mess to sort through. I knew better. I literally wrote the checklist I used to hand to clients, and I still let it slip. So I am not standing here telling you this from some place of perfect execution. I am standing here telling you this because I know exactly how easy it is to let it slide. Right. So let's get into what else can go sideways, because the beneficiary designation issue is actually just one piece of a larger legal vulnerability that could wipe out your savings. Boy, the one that really keeps me up at night, the one I want you to understand almost more than anything else, is the absence of a durable power of attorney for finances. Let me explain what this is, because the name sounds bureaucratic and intimidating, and it doesn't have to be. A durable power of attorney for finances is a legal document that designates a specific, trusted person to manage your financial affairs if you become incapacitated, if you have a stroke, if dementia takes hold, if you're in the ICU unconscious following an accident. It's the document that says, "This person has my legal authority to act on my behalf while I cannot act for myself." Here's what happens without it, and I watched this scenario unfold at least a dozen times during my practice. A husband has a sudden stroke at 71. He survives, but he's in rehabilitation for months. His wife needs to pay their mortgage, their bills, his medical costs. She tries to move money from his IRA into their joint checking account. and she can't. Because the IRA is in his name, and without a signed, notarized, legally executed power of attorney, she has no authority to touch it. Even though they've been married 38 years, even though the money was saved for both of them. Without that document, a court has to intervene. The process is called a conservatorship, and it is slow, expensive, and emotionally punishing. I've seen families spend $15,000 to $25,000 in court costs getting a conservatorship approved, all while their loved one is in a rehab facility and bills are piling up. I've seen it take 8 months to a year before anyone has legal access to money that should have been available immediately. And the whole time, the family is grieving and frightened and doing paperwork when they should be holding someone's hand. One piece of paper, a durable power of attorney, executed when the person was healthy and capable of signing, would have prevented every single one of those situations. One piece of paper. Often costs a few $100s to have an attorney draft it properly. People spend more than that on dinner, and they don't have the document. Does that make sense? You see what I'm saying? I'm not trying to scare you. I'm trying to hand you the playbook that I spent 24 years handing to clients, most of whom wished they had gotten it 20 years earlier. Now I want to share a number with you, because I think data makes things real in a way that stories alone can't. According to AARP, approximately 67% of American adults do not have a current, up-to-date will. That's 2/3 of the country. But here's the number that really gets me. And I saw this in my practice every single week. The vast majority of people who have a will have not reviewed or updated their beneficiary designations to align with that will in the last 5 or more years. Which means their carefully drafted will and their actual account beneficiaries are likely contradicting each other. 2 legal documents fighting over your assets while your family watches. I had a client, this one really stayed with me even after 24 years, a retired teacher named Dorothy, 73 years old, came in because her financial advisor suggested she update her estate plan. Smart woman, organized. She brought a folder with every account statement she owned. We went through everything line by line, and we found that her IRA, the one with $310,000 in it, her largest single asset, listed her brother Raymond as the sole beneficiary. Raymond had passed away 4 years earlier. She had 4 adult children, 6 grandchildren, and a clear intention to divide her estate among them. But because she had never updated that beneficiary designation after Raymond died, that $310,000 was going to pass to no living beneficiary and go directly into probate. She looked at me across the desk and she said, "I thought my will covered that." And I had to explain, gently and as clearly as I could, that a will doesn't cover accounts with named beneficiaries. And I watched something shift in her expression that I can only describe as stunned relief, because we found it in time. She updated the form that afternoon. Her children are now properly listed. But we both sat there knowing how close it had come. That is the conversation I want to have with you before you need it. Not after. Before. So here is the practical action plan. And I want to be very clear. This is educational content. It is not legal or financial advice for your specific situation. Every family is different. Every estate has its own complexity. Please work with a qualified estate planning attorney who actually knows your circumstances. What I can give you is the starting framework, the things to check, the questions to ask, the actions to take. Step 1. This week, not next month, not after the holidays, this week. Contact every financial institution where you have a retirement account. Your 401k administrator, your IRA custodian, your Roth IRA, any old employer plans. Ask them to send you a copy of your current beneficiary designation form for each account. Read every name on those forms. Is the relationship still accurate? Is the person still alive? Is the person still the right choice, given where your life is today? Are there contingent beneficiaries listed in case the primary beneficiary predeceases you? This is your starting point. Step 2. If you don't have a durable power of attorney for finances and a healthcare directive while you're at it, please make an appointment with an estate planning attorney this month. I know it feels like something you can get to later, but later has a habit of not arriving on schedule. This document is your insurance against a court having to step into your financial life during a crisis. It is inexpensive relative to its importance, and it is one of the most loving gifts you can give to the people who will be managing things on your behalf if something goes wrong. Step 3. Review your will. When did you last look at it? If it was drafted more than 5 years ago, or if anything meaningful has changed, a new grandchild, a death in the family, a change in your relationship with someone named in it, significant new assets, it needs to be reviewed. A will isn't a monument. It's a working document that should reflect your current life. Step 4. Talk to your family. I know this one is the hardest for many people, and I understand that. Nobody wants to sit around the dinner table discussing what happens when they die. But the practical conversation, where are the documents? Who are the advisors? What accounts exist and where? That conversation is one of the most important things you can do for the people you love. When something happens, and eventually something will, they should not have to become detectives to figure out your financial life. Give them a roadmap. And here is the thing I keep coming back to. I retired 8 months ago. I think about my grandkids. Emma is 7, Noah just turned 5, and baby Olivia is 8 months old and has absolutely no idea how much joy she brings into our house. I think about what I want to leave them. Not just money. I want to leave them clarity. I want to leave them a family that isn't fighting in a lawyer's office because Grandma didn't update a form. I want to leave them the version of me that thought about this stuff carefully and took care of it. You worked too hard for this money to let it slip away on a technicality. You spent decades being responsible, being diligent, building something real. Don't let a 2-minute oversight on a piece of paper undo all of it. Check your beneficiary designations. Get your power of attorney in order. Review your will. Have the conversation with your family. This is not complicated. It is just necessary. You can always make more money. You cannot make more time. And the time to protect what you've built is right now, while you're healthy, while you're sharp, while you're still the one holding the pen. Don't waste the youth of your senior years on a legal mistake that could have been prevented in an afternoon. This is educational content only.